parties that can't sit up there. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you. Please be seated. We're glad to have you here with us today. We'll be hearing argument in 3 cases, and we can start with our first case, number 246270, Patrick McGraw versus Teresa Gore. And, Mr. McDonald, when you're ready.
Thank you very much. If it please the court, David McDonald on behalf of the plaintiff and appellant Patrick McGraw. This appeal is the second time this case has reached this court, and this time the trial court has dismissed the case on the grounds that Mr. McGraw did not exhaust his administrative remedies. And we argued in the trial court, and again argue here today, that he did in fact exhaust those administrative remedies, because this requires the court to address the policy itself. There is no requirement in the Prisoner Litigation Reform Act that a grievance be filed. The statute only requires that the administrative remedy be complied with. And in this case, because it was a medical emergency, there is a separate procedure set out that does not involve a grievance for obtaining emergency medical care. And this is exactly what he did. That procedure requires the inmate to submit an emergency medical sick request in order to obtain the medical care that he requires. And that is what he did. In fact, he testified that the only way he ever got to see a nurse at all was by submitting an emergency medical request. That is what he did. That is what the procedure specifies that he is to do under those circumstances. And a grievance procedure does not get the matter to the right official. There's delays. It can be, the time could include months, and by this time, Mr. McGraw, if he had filed a grievance, would be dead because he didn't get the medical care.
I want to make sure I understand your argument here. So he files the sick visit because he has an emergency and he needs to see a healthcare provider immediately. But I would have thought the natural reading of this policy is that after that, if he is not sort of satisfied and he has a complaint, before he brings it to court, he has to exhaust it through the grievance policy, not before he gets the medical care, but after he gets the medical care and before he goes to court.
This is imposing an additional requirement on inmates who have emergency medical conditions. And certainly one of the things that happened here is that by following the medical procedure set out in the administrative procedure, he was able to get the medical care that he was looking for.
But that's not really that may be the basis of your claim, but it seems to me if that's right, doesn't that mean you don't have any injury that you are here in court for? I mean, if all you wanted was the medical treatment and you got it, then we wouldn't have a case. It seems like you want more, and I understand that. You want, financial recovery for the delay. But isn't that, that's part of the grievance, isn't it? Your grievance is that the delays cause damages and you now want some recovery for that. Doesn't that have to go through the grievance process under the statute?
Your Honor, I believe that the record reflects that he wouldn't have gotten the care unless he followed this procedure, because he said that he submitted other sick requests and did not get to see a nurse. And I think I encourage the court to be mindful of how difficult it was for him to see a doctor.
Sure, and I'm not quarreling with that. I'm not saying he didn't do all he needed to do to try to get medical help at the time. But I guess my question is more of what's the nature of your claim here? And it seems like it's for monetary damages based on a delay. And my question is, if that's true, the procedure that you say he exhausted, seeking emergency medical help, it seems unrelated to the thing you're suing about.
Well, if the court looks at this as a complaint that the administrative procedure was ineffective, it was ineffective. He submitted an emergency medical request and got to see a nurse, but did not get to see a doctor. The nurse did not put him through to a medical professional who was capable of making a diagnosis or giving a prescription. He had to go back a second time.
Totally get all that, and that may entitle you to recover damages. The question is, under this act, do you not have to file that claim with through the administrative procedures first?
I suggest that the court needs to take reference to the purposes of the act. The purposes of the act is to provide the administration with advance notice at a time when they can address a concern. This process that's specified in their policy does allow that. They had an opportunity, they had several opportunities to address the problem, and he submitted several emergency sick requests to do that. The next requirement is it gives them an opportunity to create a record. There's a complete record that deals with virtually every issue that is presented in this case because it began with the documentation of the emergency sick call request. The nurses took notes as to what happened. They memorialized that they did not put him through to a medical care provider for 3 or 4 times in weeks. He came back again and again with the same complaint. At one point, and I think this was the third interaction that he had with them, asking to see a doctor, and they wouldn't let him do it. He said
just to help me understand, and maybe this will be the last time I'll ask it. I think both my colleagues have asked it. I'm just going to take another swing at it to see if maybe my question gets answered. What is the remedy that you're seeking in this lawsuit?
Well, we are seeking compensation for his injuries.
Right. Damages, right?
That's correct.
Right. And the damages you're seeking are as a result of the past conduct of the prison.
Everything that is spelled out in the administrative remedy
Wait,
procedure.
but stop for a second. The damages you're seeking are for the past conduct of the prison officials, right?
The same conduct that, yes, the
Right,
same
past
conduct that is.
things they didn't do in the past. I mean, this is like a basic idea, but like it's things that the prison officials did in the past or failed to do in the past.
Well,
That's what you're seeking damages for.
That's correct, but it's those same things that he was following the
And
administrative
then,
procedure.
so help me understand, so the emergency provision says that it applies when what you're seeking presents a substantial risk of physical injury. And so how are the damages that you're seeking for past conduct in any sense an emergency such that it presents a substantial risk of physical injury? What you're seeking, not what happened in the past, because that no longer presents any risk of injury. It has happened or not happened. He got the injury or didn't get the injury. It doesn't present it today, right? And so that is past. How is what you're seeking present any risk of injury? I mean, presents a potential recovery, right? It presents a risk of financial loss to the state, but it doesn't present any risk of injury today, the claim you're making.
No, it no longer presents an injury because the injury already occurred. The injury occurred because the administrative policy was not effective to get him to see a doctor in time before this infection set in and destroyed the love of his lungs.
Just to tie the bow for me, help me understand why, given your concession that your claim does not present a risk of injury today, the claim that you have brought and the remedy you're seeking, tell me again why you can not exhaust, like why you're excused from exhaustion? Because you plainly don't fall in 0308. We've just conceded that. And so why is it that you don't have to exhaust?
Because he did exhaust the remedies, and the financial consequences, they couldn't have compensated him for that anyway. They
I'm sorry, the
wouldn't.
financial consequences, they couldn't have compensated him for that anyway. Or say that a different way, because that seems like a word salad.
I'm sorry. The grievance procedure does not lead to monetary damages, so he couldn't get that through the administrative procedure, no matter what he did.
But that may be true. That may be completely true, but hadn't the Supreme Court told us that that is not a basis for exhausting? That Congress has said you must exhaust, and that may seem, inefficient and maybe even silly in a case like this. I can understand someone saying that, but hasn't the Supreme Court told us that if you can't get money through the administrative procedures, that's irrelevant under the statute? You have to do it and go through the motions anyway, because Congress apparently felt like in enough cases that would help resolve prison complaints.
Your Honor, I believe that the purposes of the statute are not served by this, because one of the purposes of the statute that's laid out by the Supreme Court in the Jones decision is to allow the courts to consider meritorious claims and to throw out the frivolous claims. This is not a frivolous claim, and the trial court has determined that. And what this additional requirement of filing a grievance, the only thing that it accomplishes, it doesn't accomplish any of the purposes that are set out for the Litigation Reform Act. Right. It only accomplishes one thing, and it accomplishes exculpation of the prison officials who violate the Constitution. Right. And on a technicality, here, Mr. McGraw, this 90-day period that they contend has for filing a grievance, at least 43 days of that ran while he was in intensive care after brain surgery, removing a portion of his brain, and then there was an additional period that he was in recovery while he was at Central Prison when he was returned. And there's suggestions in this court that this procedure has a tolling provision. And if there's a tolling provision, surely it should apply for the time. And frankly, I don't see how the other side could defend a grievance procedure that didn't take into account the prisoner's condition, particularly given here that he had difficulty reading. He can't.
Counsel, can I just ask you something about that? Because the way I read the district court opinion, it seemed that the district court did take into account the time in the hospital, certainly, right? The district court didn't hold that time against your client. The district court said after he's out of the hospital, there's 62 days between that and his release from prison, and at no point during that 2-month period did he file his grievance. So I didn't really understand the district court almost to be disagreeing with you on the idea that, look, he's having brain surgery, you cannot hold that time against him.
Your Honor, Mr. McGraw has documented limited ability to read and write. He was a special needs student in school.
Well, that, I totally understand that, but
he-
the PLRA doesn't really, I don't think, and I don't think this court has suggested that there's an exception for for that, for being a special needs student.
Well, and frankly, I don't see how a grievance policy that doesn't take that into
Well,
consideration.
there's assistance available, right?
Yes, but if it's available, that does not mean that he has access to it. And he said in his deposition testimony that because of the nature of his injury, nobody was willing to go near him, and he couldn't interact with other inmates, and that no one wanted to talk to him about anything. frankly, I think it's placing too difficult a burden. I'm sorry, may I finish my sentence?
Of course.
Is placing too difficult a burden upon him to initiate all of this process while he's in the process of recovery, because his recovery didn't stop when they released him from UNC Hospital. His recovery continued when they readmitted him to the Central Prison Hospital.
Thank you, and you do have some time on rebuttal.
Thank you.
Hey, please court. My name is Alex Williams, and I represent the defendant, appellees. It is unfortunate what happened to plaintiff, but that is not the fault of the defendants. It is certainly not their fault that plaintiff did not file a grievance. This case boils down to two simple questions. Is a written grievance required under the administrative remedy, and is plaintiff excused for failing to do so? And if we accept plaintiff's arguments, it's going to wreak havoc on the prison system for three reasons. Allowing non-written grievances or sick calls as plaintiff.
Can I back you up to sort of a premise here?
Please.
It strikes me as a little bit odd that the PLRA applies. And I guess the question I've got, so he gets out of prison in 2016, and then he's put back in prison in 2018, and then he files the suit in 2019. Right? He's in prison for a different reason now, right? He's committed another crime, and he's now reincarcerated. If he had filed this lawsuit in 2017, so he had not exhausted, right? He had done exactly what he'd done, but instead of waiting until 2019, he had filed in 2017, which is the 1 year that he managed to not get caught. Would the PLRA have applied then?
Your Honor, the PLRA says that no action shall be brought by a prisoner. So I think in this court, I believe it is Cofield versus Bowser, 4th Circuit, 247, Fed Appendix 413, so that it's the status of the plaintiff at the time that he files the suit.
Right.
So you are correct. If he were out of prison in 2017 and he filed this lawsuit, the PLRA would not apply. However, that's not what we have.
Yeah, no, I totally get, right? That's why I'm asking the hypothetical, right? But, and so, in a sense, he could have filed suit and received recovery as long as he filed that suit in 2017. It's really the delay until after he gets caught and reincarcerated that reinstigates the PLRA's exhaustion requirement. That just seems like an oddity. I think you're right about that, but that seems odd to me.
Your Honor, I understand that, but this is not the only time that this has come up. Mm-hmm. And in other situations where this has come up, again, this court and others have held that it's his status at the time. And that's why, we have inmates who pass away and they don't have to comply with the PLRA because, again, they're not a prisoner at the time that they're filing their suit.
And you're also, I think this is right, and it's also just when he files suit, the fact that he maybe gets out of prison, as he does here, while the suit is pending, doesn't make any difference. It's literally just the moment that he files the suit.
That's correct. I believe that's the way the cases have interpreted the PLRA, yes. And so in this case, if we allow, as plaintiff suggests, him to be excused from that by submitting these sick calls, it's inconsistent with the PLRA's purpose, which is to give notice to prison officials. If a sick call can satisfy a grievance, we're not giving notice to anybody other than the person whom he's seeking medical care for.
Well, so I totally understand the argument about the text and why your argument makes sense. But if we're talking about the purpose, do we really think the prison officials didn't know what was going on here, right? I mean, he's got like a flesh-eating thing on his body. I mean, this is something that the prison officials were aware of, right? They were giving him the treatment. This doesn't strike me as the sort of thing the prison didn't sort of recognize was a problem.
Your Honor, I think the purpose of the notice serves more than just okay, we know that this guy has this problem. It's, did he complain about it? Did he ask for help multiple times? The difference between seeking medical care and complaining about a lack of medical care are two very different things. The sick calls that he keeps talking about, that's how you get medical care. That's not how you complain about a delay in medical care. And the difference is
It seems
significant.
like it can kind of be both, right? I mean, just as a common sense matter, like you go in once, they don't help you. You come back the next day and you say, I'm still sick. The thing you did a couple of days ago did not fix it. Like, it can be both, right?
I don't think so because of where it goes. And the reason the sick calls go to medical. There's a nurse that triages them and figures out what needs to happen. That's the end of it. The grievances, they get resolved at the unit level first at step 1, then at the facility level at step 2, and then at a state inmate grievance resolution board at step 3. So you're putting people on notice higher than the person you're complaining about. If we allow that sick call to serve as the grievance, the only person who's getting notice is the same person who's allegedly aggrieving the inmate. And so that's not putting the prison on notice. So it's not satisfying the purpose of the PLRA.
But just to kind of look at, if you think that, if the complaint is the harm caused by the delay, and that's in the past, and you're seeking damages, it does seem to me that this exercise of filing a grievance for money damages based on past conduct is somewhat pointless or futile in this situation. Now, that doesn't mean that it's not required by the text and it's not required by the Supreme Court. But, just to follow up, I mean, it seems like your argument is textual and Supreme Court precedent and not the purposes of anything. Because, one might argue the application of the text, doesn't present the most fair situation for the plaintiff here. But, that doesn't mean we don't have to follow the law. So I wonder why you're not just saying the text says this, the Supreme Court has said it a couple times. I mean, the law may get you there, but, the purposes of the act and fairness and equities seem like they're not on your side, or at least they're debatable.
Your Honor, I think the law does get me there. I think you're right. In Woodford, the Supreme Court did say that PLRA exhaustion is required even if you can't get what you want through the administrative remedy procedure. And I think that the text is very clear that this is not, he had to file a grievance and he didn't do it. And so I do think that legally we get there, but even from an equitable standpoint, even after he was, let's kind of live in hypothetical land here for a second and say that he gets 43 days equitably told. Just like the just like the district court said, I'm gonna discount that period for you. You still had approximately 60 days where you were incarcerated and you did nothing.
Right.
You didn't file a grievance. And when we look at equitable tolling principles, there are two components to it. First, you have to have that extraordinary circumstance. And even if we say that plaintiff's infection satisfied that part of it, equitable tolling only gets you to the point of excusing tardiness. Right. It does not excuse a complete failure, which is what we have here.
Can I ask, sort of, just in terms of the timing, did I cut you off?
I got something. Go
Okay,
ahead.
and just in terms of the timing, what you were talking about with the equitable tolling, like, does the prison have a policy about this? Like, what if Mr. McGraw had in fact filed a grievance before he was released on his, the current, what was the then current term of imprisonment? Before he's released, he files something on like August 10th, the day before he's released. So it would be outside the 90-day period, be more than 90 days since the incident, but a big chunk of that time he would have spent having brain surgery. Would the prison have said, that's late, you're outside the 90 days? Or would the prison have said, okay, under the circumstances, we'll count this one?
So unfortunately, we don't know the answer to that.
Well, I was asking you if there's a policy.
Yes, Your Honor, there is a policy, and in section 306B and C, that is the rejection of grievances. B says shall, and it lists a few things.
Understood.
C says may.
Right, so I'm asking, how does the prison exercise that discretion in a situation like this, where someone files a grievance more than 90 days after the the incident that gave rise to the grievance, but during some portion of that time, the person was in the hospital being operated on.
Your Honor, I don't know that I've seen a particular situation like this, but I think I have seen situations where inmates have filed outside the 90-day period and the grievances have been allowed to proceed. And that is allowable under the administrative remedy procedure. So I do think that if the prison official wanted to, they could allow him to proceed after 90 days.
Can I go back to Judge Quattlebaum's question? Do you accept, is the premise correct? So that money or things of value cannot be provided through the grievance process? So imagine the scenario where somebody comes in and says, I've got this terrible grievance where your guard like senselessly beat me, and the process goes through and the, prison system says, absolutely, you're right. They fire the guard, and they go to the prisoner and they say, this is really terrible, and we want to offer you $10,000 as a result to, settle any future claims to resolve this process because, listen, it was really terrible. It's on video. We totally get, like, this should never have happened to you. We want to make it right. Is that something that the state could do, or is that barred by statute or procedure in some way?
Your Honor, I don't think there's anything that bars it by statute or procedure, and quite frankly, I will use a different example than Your Honor's, but in property-type claims, the state will commonly, through this grievance procedure, either refund inmates or things of that nature if they realize.
Can you give me an example of that when you say a property-type claim? Can you tell me like what, or just some hypothetical example where that would result in, some thing of value, money being put in the canteen account, whatever it might be?
So if an inmate's trust account is incorrectly withdrawn from or something along those lines, the prison can go back and compensate them for that.
Okay.
I think in lost property claims, I think I've seen it with a grievance before.
What do you mean by lost property claims? Like if the state is supposed to be in charge of their property and it shows up missing when they get ready to be released, they had it when it was inventoried, they go to leave and turns out the $500 that was in their pocket isn't there anymore.
Exactly, something
Or
along
a
those
watch
lines.
or whatever it might be.
Something along those lines, I believe I have seen that. And so I do think that there is a possibility for compensation under the administrative remedy procedure. There's nothing under statute or rule that would bar it. Now, I do think that we would obviously have some quarrels about the amount of damages when you're starting to talk about a
I'm not saying
situation.
it's likely. I totally understand it's not likely. But what I took Judge Quattlebaum's question to be premised on the idea that damages were not available in the grievance system. And that may practically be true, but it doesn't seem to be like absolutely true.
It is not absolutely true. I'm not aware of anything that would bar it. And so when we look at this, plaintiff kind of talks about briefly that he is, he claims that if we get past the part and say, yes, you were required to submit a grievance and you didn't do so. And plaintiff says that the reason I didn't do so was because I was so mentally incapable and all of those things. Well, with respect to Mr. McDonald, I think that he's putting some labels and some conclusions on it that the record evidence just does not support. The district court looked at all the evidence and it found that plaintiff had not satisfied anything to show that he was incapable of doing so. The administrative remedy procedure, even if he did, the administrative remedy procedure accounts for that. It says that if you are incapable of understanding this procedure or incapable of complying with it, you can get assistance. And there's not been any evidence to suggest that plaintiff ever requested assistance. So the administrative remedy procedure was available to plaintiff. He just simply failed to comply with it.
Can I ask you just, the district court did do that, like really careful kind of walking through the chronology. And here, right, he's released from prison with 62 days to go he's released from the hospital with 62 days to go before he's released from prison. But it just hadn't occurred to me before this case. What happens what if he'd been released from prison the next day? Like, what if he got out of the hospital on whatever it was, June 10th? And then he was released from prison on June 11th. Would you still say, like, whatever, he had a day, he should have filed a grievance?
I would say, and I assume in your hypothetical, he does get reincarcerated again.
No, let's assume he doesn't.
Well, if he doesn't get reincarcerated again, I mean, he's.
Oh, that's true, then he never, the
doesn't have
PLRA
to
never,
exhaust.
okay, so he gets reincarcerated.
So under your example, if he does get reincarcerated, I think he would still have to at least file a grievance. If it gets rejected, I think we're in a much different place.
I see, if it gets, so if he filed then, and then the prison said, you're too late, it's more than 90 days, then what?
I think we're in a different place than we are here, and in that scenario, there have been courts that have held that an inmate must appeal a rejection, and I don't think the plaintiff, we know he never filed one here, but under your hypothetical, he would have to appeal, I think, that rejection.
But I guess I'm just wondering, what is the prison's, like, this case in some ways seemed to the district court to be pretty straightforward. Look, you had 62 days, that's a lot of time. If you wanted to file a grievance, you could have. And I'm just wondering what happens if there's not a lot of time? What if it's kind of close? Like, what would the prison's position be? I understand there would be an appeal, but that doesn't really answer the question. What would the prison be saying in that appeal?
So again, I think that goes back to 306C where it says they may reject,
Right,
they
I
don't
know,
have
I
to.
also saw that, but I couldn't find anything about how they would exercise that discretion. And I'm just asking you whether you know, does the prison have a policy about how it exercises the discretion it has under this policy not to enforce the 90-day time limit?
I'm not aware of any specific policy about how to exercise the discretion laid out in 306C. But I think the discretion is there. I think it does make this remedy procedure available to plaintiff. He just simply failed to take advantage of it. So in concluding, I do think, I agree with the district court, this is a pretty simple case. I do think that at the end of the day, plaintiff had, like Your Honor said, over 60 days from the time he was released from the hospital to the time he was released from custody to file a grievance. He did not. He had over a year when he was reincarcerated to file a grievance. He did not. At no point in time did he try to take advantage of the administrative remedy procedure. And now he's expecting the court to excuse his failure. The PLRA does not include those types of exceptions. The sole exception to the PLRA is if the administrative remedy procedure was unavailable to him. However, we clearly see that it was available to him. So we would ask that Your Honors affirm the district court and dismiss the case.
And we're now in a context that doesn't apply, and you can choose to just say, I don't know. But would the argument in response to Judge Harris's question that if he's like released from the hospital the day that he is like conscious, that the argument would be made there that the grievance process would not have been made available to him in a reasonable way? Right? I mean, if he got out that day and then in that sort of context, I'm not saying it works or doesn't work, but the argument would be it wasn't available to him. There wasn't a grievance process available because by the time he was conscious, he was already released from prison.
I draw a slight distinction between yours and Judge Harris's example because I think they're slightly different. Judge Harris, I think, had a day built in between, and so I'm going to take advantage.
My next question was going to be that, so.
Yeah, right. I mean, and then we have some debate about whether it's available, right? But that, and I understand that debate, but that would seem to be the question that we would ask, right? Of whether it was, quote unquote, available in whatever hypothetical we want to give. That would have to be the inquiry. Is that a fair way of thinking about it?
Yes, I think that's right, but I think in this scenario, in the scenario you're proposing, he becomes conscious after he's already released. You're right, it would not be available to him during that time. However, he was reincarcerated for a year when it was.
And then we'd have that
available.
question too about whether it's available given C's discretionary review process.
And so he had another year to file a grievance, and he still did not. And so I think
Would
any
we-
way
Would we
you.
have any questions? Sorry, this is all very hypothetical, but there is this opaqueness, it's just kind of opaque. And I do wonder, like a prisoner who's reincarcerated, there's really nothing in the maybe it doesn't happen that often, so you wouldn't expect to see anything in the policy. But would it be obvious? Like, would that prisoner really be on notice? Like if something happened 5 years ago, the first time you were incarcerated, you need to exhaust that now?
Your Honor, I think our courts have done a very good job of putting inmates on notice that they have to comply with administrative remedies. So I would say that first, but also I would say that when we look at this, this is like Your Honor said, a very odd scenario. I think that if we are forcing prison systems to dream up every odd scenario and account for them in a step-by-step fashion in their administrative remedy procedure, that is taking it beyond what the PLRA is requiring. It is not requiring us to dream up every situation. It's merely requiring that there be an administrative remedy procedure that is available to inmates. This was, he just did not take advantage of it.
Thank you very much.
Thank you.
And Mr. McDonald, you've got some rebuttal time.
If it please the court, I believe that the period of time that Mr. McGraw was an inpatient at the hospital was 43 days. That would leave 47 days remaining on his 90 days. If there's no tolling, that time expired before he was released from prison the first time. But that policy, since it doesn't seem to take into account the prisoner's condition, can't be squared with the Constitution. If there's a,
But that wasn't, you're saying that the 90-day policy, to the extent it doesn't take into account his condition, can't be constitutionally applied. But I guess nobody did apply the 90-day limit to your client, right? It's not as though he filed a grievance and they said, you're too late.
that's correct.
Well, then
but
I guess I don't see why there's a timeliness issue in this case.
If tolling is a feature of this policy, and this court suggested it is, and I believe I heard a concession from opposing counsel that it is,
Wait, what was that? I didn't hear that. What he said was that the prison has discretion, right? Tolling is a, court doctrine. What he said is, under C, the prison has discretion.
I see. Okay,
If you think you did, I just want to know what it is that you thought was such a concession, because I didn't hear such a thing.
well, I think what he said was that missing the deadline is not automatically a rejection.
Yeah, that's what 306C says.
Right.
And he's just repeating what the provision says.
Okay, so let's assume there is tolling here. If there's tolling for the 43 days, that starts the 90 days at least for that period of time, if not longer. And at that point, he had been released when before the 47 days, before the 90 days had expired. Now, there's nothing in this procedure, there is nothing in the law that suggests that if he is later reincarcerated, that the balance of that term begins to run again. And if that's a feature of this policy, surely it ought to be in the policy.
So I totally understand what you're saying, like he didn't miss a deadline before he was released. But all of that, it just strikes me that all of that would be highly relevant if someone was trying to enforce the deadline against your client, but nobody is. So I really am kind of wrestling conceptually with how we have a timeliness question in this case, given that nobody has rejected a grievance here as untimely.
The trial court said that he missed the deadline and threw his case out.
No, I thought the trial court said he didn't file a grievance and the grievance process was available because there were 62 days in which he could have.
Well, the trial court, I believe, explicitly found that the time period expired while he was still a prisoner in central prison. And therefore, it operated against him because he had not filed a grievance within that
So
period
you
of
understand the
time.
district court to have held, the reason you didn't exhaust is because you missed the 90-day deadline.
Right.
Okay.
So the trial court has done that.
Just so we're clear, I think the record's clear, whether it was within the 90 days or after in the time period he was incarcerated the second time, no grievance was ever filed. You concede that, correct?
Certainly.
Okay.
there was no grievance filed when he returned to prison a year or two later. That's correct, Your Honor. But the 90 days had expired. The 90 days expired while he was free. And I don't know how it revives. I don't know why the law would require that.
And just so I understand, your argument that the 90-day didn't expire until he was out of prison turns on some suggestion of tolling?
That's correct.
And just help me understand, where do we get that from? I mean, most tolling doesn't operate in a world that we ignore the time, right? It may extend the time given reasonable efforts and lots of different things, but we don't normally think of tolling, even if it applied, which it's not obvious to me why in the world it would here. But we don't normally think of tolling as saying, we just don't start the clock until we decide it's a good time to start the clock.
Well, here, the clock started, according to the trial court, the 90-day clock began when he actually resolved his dispute with the nurses and got to see a doctor. Now, from my
And 90
perspective,
days from that point, he was still incarcerated, right?
90 days from that point, of which 43 days he was in the hospital, in intensive care much of that time. And frankly, I don't see how the court can hold him responsible for formulating a need to file a lawsuit based on consequences that have not become even apparent at the time, although we know that they were catastrophic, while he's in intensive care from brain surgery, frankly, Your Honor. But in any event, that time expired, and he was released before he was required to file a grievance. And at that point, he no longer had an obligation to file a grievance, and it wasn't available to him. Finally, there's a difference between a sick call and an emergency sick call. A sick call is something that you submit. Those were completely ineffective. He invoked the process of the administrative remedy procedure by submitting the emergency sick call request. Those were ineffective, and it's all documented, and that's his complaint, is that he did not get to see a doctor until it was too late. I believe my time is complete. If I
Thank
may,
you very
thank
much.
you very much for your attention.
Thanks. We will come down and greet counsel. We'll come down and greet counsel and then hear our next case. Number 241102, Brown versus Walmart, and Mr. Hawkins, whenever you're ready.
If it please the court, I'm David Hawkins, and I've represented the plaintiff below, the appellant here today. Apologize to the court, I seem to be losing my voice. Probably a bad thing for a lawyer, a good thing for the court, probably. But in this case, the district court erred in ruling that the plaintiff must prove the defendant had actual or constructive knowledge of the specific ice patch that caused the plaintiff's fall and injury. Now, this is a Virginia snowstorm case. Snow began late the night before, about 10:15 p.m. At that time, temperatures were above freezing. So it's common sense, snow falling on black asphalt, above freezing temperatures, there's likely to be melting. As we get past midnight, the temperatures drop, and they drop below freezing at that point. Common sense, once again, tells us ice is going to fall. The snow continues heavily, more heavily, like 3 or 4 in the morning, tapers off and ends about 6:15 a.m. That morning, the plaintiff comes at about 8:30, I think 8:31 in the video, steps out, slips on ice, and falls. The court below applied the standard that is in a dangerous substance case on the floor and said that the plaintiff had to prove that Walmart, the defendant, had knowledge of the specific ice patch
So
in
counsel,
which
can
she
I
fell.
kind of interrupt you? And I
Yes, sir.
appreciate you going through that. My questions kind of is on this notice issue. And I'm trying to understand how notice works in your view on this not ice and snow question. Is it your view that Virginia law says we don't look at notice at all if there's inclement weather? Or is it that reports of inclement weather and temperatures, constructively put, Walmart here on notice? I'm just trying to understand. I understand your argument that we got different cases from a banana peel in a grocery store and an ice. And you don't think they have to, Virginia law requires there to be notice of the specific, slick spot of black ice. I'm just trying to conceptually understand, is it because if there's general bad weather conditions or reports, that's constructive notice? Or do we just not look at notice in snow and ice cases?
First, I wouldn't say general bad weather conditions.
Okay.
I think the rule is specific to snowstorm cases. All right. And in that case, notice of the fact that there potentially could be a dangerous condition on the premises outside where the snowstorm occurred is presumed from the fact of the storm.
But just playing that out, snowstorm sounds kind of obvious, but maybe it's not. I mean, how do you know, what's a snowstorm?
That's when the snow comes down, I would say, but may I just say, in this case, we got 2 inches of snow. So I don't think
I
it's any
got-
question here.
But we got, we're trying to apply
Yeah.
Virginia law, and we're trying to understand what it is, and we could say, hey, we don't need to worry about the rule because here there's 2 inches of snow. But I'm trying to understand the rule from a Virginia law standpoint on snowstorm, because, if snow comes out, if a couple flakes come out the sky at, sometime at the night, but it doesn't stick anywhere, maybe that's a snowstorm, maybe it's not a snowstorm. I'm just trying to understand what your view of it is. Maybe that is still notice, and all that goes into what the duty is. You understand my question? It's
I
not
think so.
case specific. It's how do we think about this
Well-
concept of snow and ice storm?
Can I say that I think it is case specific? How much snow do you have to have before the duty to remove? And that's what the rule is in Virginia. That is, the owner has a duty to remove, take reasonable steps to remove the ice and snow. And your question being, when does that occur? And I would say, in my opinion, it has to be some accumulation of something, because otherwise you wouldn't have a duty to
Well,
remove.
that's your opinion, and we appreciate it,
But
but is there a case that?
There's no case. But can I tell you, I think there are 3 instances of cases, and
Wait, before you get to that, can I just,
Yes.
because I had a bunch of the same questions, and I am genuinely confused by this. So I'm sorry, there doesn't have to be accumulation.
Oh, I think there does.
There does have to be
But no
accumulation.
case-
So let me just, so had it just rained and then frozen, we'd be in a whole different, then none of this would apply.
I don't know. There's been no case that's ruled on that. All the cases.
But it's so weird, because it's not as though your client slipped on snow. The snow had been removed. What she slipped on was ice, and you could have had the ice without the accumulation. So I also am trying to figure out how this works.
Well, in this case, you didn't have the ice without the accumulation though, because it snowed, it melted, then it froze. That's what is in the record here. The only Virginia case is the Virginia case, there's no
Why
case
would-
about
So you think the
freezing.
Virginia, and maybe this is right, so Virginia law treats differently ice that results from frozen rain or rain that freezes versus ice that results from snow that melted?
I'm not saying that. I'm saying that there's no case that I can point to that says what Virginia would rule if it rained and froze.
Okay.
Because
So-
the question seems to be, I take what you're saying, is that the point is that a storm may provide notice. But in order to provide notice, it needs to be notice, right? So if there's snow falling out of the sky, we sort of presume, I think is the word you use, we presume that people can see the snow and understand it. If instead we have rain and a later freeze, that might not provide notice because we're sort of assuming a lot of work on behalf of the reasonable person to recognize, the temperature at 5 a.m., right? They may well see the snow, but the question is like, would it provide a reasonable person with notice? I mean, it seems like to me, I don't see these as being different cases, right? The question is, would it provide a reasonable person notice that this is taking place? And maybe in some cases it would, and maybe in other cases it wouldn't. But the clean line is when you see white stuff falling out of the sky, like that doesn't take a meteorologist to understand that there may well be a problem with snow and ice.
Yes, sir, and I would certainly agree with your last statement. All I can say is there's no case in Virginia that has said what happens when it rains and then freezes. I would certainly argue that if it's temperatures are freezing and you've got freezing rain and the temperatures fall, then certainly everyone, it's common sense, everyone would be on notice. There are going to be slick spots, there are going to be icy spots. And then there should be a duty then to go out and do something, put down chemicals, take reasonable steps to clear. But that is not the case here. The case here is we had 2 inches of snow.
So, we've asked a lot of questions that it shows, at least it seems to show, we're trying to figure out exactly how this works. Is there, and I realize there is a specific question of whether you have to know the general danger or whether you have to know the specific spot. But is there some thought here that, from your perspective, that notice is kind of beside the point? Because they called the contractor and said, come do your work.
Yes,
So,
sir.
I mean, if you've done that, is notice still an issue?
I don't think it's an issue in this case to begin with. I don't think it should have been an issue legally. If I had to argue, which I don't think I should have to, that notice was there, then I would say everybody knew it started snowing when it was melting. Everybody knew the temperatures dropped, it was freezing. The manager knew when he got there that morning that he almost slipped and busted his ass. They put down salt, employees did, on the sidewalks. Certainly they knew there was ice there. Why would they put down salt otherwise? And then they get the contractors to come in. Surely they knew there was potentially dangerous conditions out in that parking lot. Why would they take all those steps
But we still
otherwise?
have, and I get that argument, that's why I asked the question. But you still have the legal question of whether you have to have the general knowledge versus the knowledge of the specific location of the ice, right?
No, sir. Because,
Excuse me?
no, sir, because that's not the rule in Virginia. The rule in Virginia is, once you have the storm, the only duty is the duty to take reasonable steps to clear.
I got you. I'm not suggesting
sorry.
you were wrong there. I was saying that's your position and that your colleague has a different position. That's the question we got to answer, right?
Yes, sir. And may I say, I think there are 3 clear instances where Virginia has made this rule. Number one, I really, getting close to the end, but I referred to the model jury instructions and the comments there. That's a panel of eminent judges, lawyers, and academics who are approved and appointed by the Chief Justice of the Virginia Supreme Court. Those instructions are the Bible for lawyers in Virginia and judges as to what the law is. I'm not aware of a single case where the Virginia Supreme Court has refused or has said that the model jury got it wrong. And the commentary there says in a snow and ice storm, use the second one.
Can I stop? I understand you got 2 more that you can talk about, but you got a little bit of time. Can we turn to the second question? Like, assuming that there was notice here, the second question is whether they didn't, because a contractor was there, showed up. Tell me why you think that having the contractor show up and the evidence they have of what the contractor did isn't sufficient to satisfy their, reasonable standard of care?
If you examine that video closely, he drives down the lane, he doesn't scrape, he doesn't put down any chemicals. Where people step out of their cars is in the parking areas. Nothing was done there.
So can I ask you that question? So when we look at the still shots from the store and the video, do you take that as being, as basically rebutting the testimony from Walmart that the contractor put down chemicals and salt, right? The risk manager who said, he came and he put down chemicals and salt, and you think that's just like flat false, and we know it's false because we can see the video, and when he drives through, there's no, sprinkling of salt in the water that's around the truck or anything else.
And there's more to it than that even.
But is that the sort of linchpin of the story, right? Is that if we didn't have the video at all, there would only be evidence that he put these chemicals and salt out, but given the video, there's at least a dispute about whether what the Walmart executive said was true.
No, there's more to it than the video. When the manager comes out, he looks and he says, there's no salt here, and that's in the testimony. He said there was no salt put down where the people get out of their cars. He directly says that. And then, of course, when the plaintiff falls, she says, I got no chemicals at all on my clothes. And so there's certainly evidence that they did nothing in those spots. And then the third thing is the pictures, the still pictures taken by the manager, where he's 15 feet away maybe from where she fell. You can clearly see snow and ice in those areas.
Let me talk about that. Let's assume we didn't have a video and we didn't have the manager in this case. I just want to understand generally. But Walmart or whoever calls a contractor, they do some work, spread some snow and ice, maybe spread some chemicals, maybe they put their scraper down, but they don't get every spot. Is it your position that in the case of snow and ice, it's the responsibility of the store or the landowner to eliminate every piece, every little location of ice in a parking lot?
No, sir, they're not an insurer, and I agree with that statement. But the cases say they have to make a systematic effort.
So if they had done it and they had sprayed or they had scraped and had missed a spot, you'd say, that might be reasonable response.
Yes, sir.
Even though there might have been this particular spot that was left unremedied?
Yes, sir.
And I take it that part of your argument also is it's not sufficient just to come in and clear the snow and the ice that is sort of there at the moment, because that's going to leave naturally some moisture which may refreeze. So clearing it away is not sufficient. You have to salt it or apply some chemical to prevent refreezing.
That would be what I would say would be reasonable steps. That would be my argument. They didn't take reasonable steps here. I'd ask you to look at Langland Road.
Well, I guess just so I make sure I understand. So yes, like it is not enough to clear away the snow and ice. You have to use chemicals to prevent refreezing.
I think that would be the argument that they didn't take reasonable steps because they didn't do anything in the areas where people get out of their cars.
So
Yes.
I truly, so yes, you have to use chemicals or salt. Because I don't
If there's
understand, I
ice-
looked at the pictures, your own plaintiff, they say, like, when I stepped out of the car, there was nothing visible on the ground. So
But-
obviously, they had cleared away the 2 inches of snow.
But if you look at the manager's pictures, they show the ice and snow, and the manager, when he comes out, says it's slushy, and then he says,
Well, I
in
looked
part
at
of the
the
language
pictures
shift,
and-
this is ice.
Okay.
That's what he says. He saw it.
Okay, so you don't need this, so you can say, I really do want to understand what your argument is. So you do not need it, even if they didn't salt, and even if they didn't put down chemicals, that might be okay. But in fact, here, the record is uncontroverted that there was visible snow and ice in the
Correct.
parking lot, is what you would say.
Yes, ma'am. And that's clearly in the record. Thank you.
May it please the court, Victor Scaff here on behalf of Walmart. It is black letter law in Virginia and in the circuit that in a premises liability case, a plaintiff must prove evidence of the defendant's actual or constructive notice of a dangerous condition, and constructive notice may be shown by evidence that the defect was noticeable and had existed long enough to charge the defendant with notice of it. Contrary to what the plaintiff argues in this case, that is what the law is. That's black letter law, and there have been no exceptions carved out for snow and ice by this court or by the Supreme Court of Virginia. Here, the district court was correct. The district court considered all of the evidence before the record and found no evidence of actual notice of the specific defect that caused the fault, the icy patch here in this case.
Can I ask about the district court's analysis? Because there's the bit where the manager allegedly says, you know, as he's looking at the site of the plaintiff's accident, oh, I almost busted my rear end in the parking lot this morning. And the district court seems to have held that no reasonable jury could infer from that statement that he meant the parking lot he was currently standing in?
Yes, ma'am. So,
How is that not the world's most natural inference?
because the plaintiff, in her
Was there
testimony,
another parking lot that was alluded to somewhere in this record? Like, had he stopped in a different parking lot on his way to work?
well, he had gotten out of his apartment, I believe, and walked through a parking lot, and then he got to the store, and then he parked in a totally different area
All right,
of
but
the
that's
store.
a different
Yes,
question,
ma'am.
like what he meant when he said, oh, I also
Well, I-
almost busted my rear end in the parking
Well,
lot this morning.
I think there were two parts to it. Number one, the plaintiff testified. She made that statement that he made that statement, that he almost busted his butt. But he didn't, when I asked her specifically, did he say where that was? No. Did he say it was even in this parking lot? No. Did he say when that was? No. And so that was that part of
Wait,
it.
your story is that like, that was at his parking lot at his house?
It could have been.
2 days ago?
Well, that had not been
All right,
established
but
by
that, I just want to understand, that's your theory.
No, Judge, all I'm saying is that the evidence that the plaintiff put forward was insufficient because she couldn't establish any of those
Because
things.
it could have been that he was talking about 6 months ago when he was in Aspen?
It's possible, but I think it could have been anywhere. is
You
my
should stick
point.
to that argument. Try that one before the jury. That one's going to work well for you.
No, well, I guess my point is that there was nothing to establish. No reasonable juror, based on that statement, could find that that's where and then his testimony was.
Wait, just to be clear, he says, we're assuming now the truth of it, he says, while he is investigating the site of the plaintiff's accident, I believe he's kind of crouched down looking at the ice, and he says, oh, I almost busted my rear in the parking lot this morning. And from that, no reasonable jury could infer that he meant the parking lot he was currently standing in.
Yes, ma'am. Without more
No.
detail, that was the plaintiff's, it was just, that's what he said. This is what he said to me. But without more, it was insufficient to prove that there was notice of that actual condition.
Isn't that what juries are for? They hear that statement and they decide whether he meant that parking lot. And to say that that would be an unreasonable inference for a jury to draw just strikes me as extraordinary. But I'm not sure you need to defend this. I don't know that you want to die on this hill.
No, I just think, I believe that based upon, that was her testimony, and based
I
upon
mean, it
that,
does suggest that if you think that's the hill that you need to die on, it suggests that you don't believe that you have a, like, prevailing argument. If that's really the argument that you're making, like that suggests, like when people make wildly unreasonable arguments, it suggests that they do not have reasonable arguments, right? And so that suggests to me that you do not have a reasonable
No,
argument.
Judge, even if you believe, even if that is enough to establish actual notice, it also has to be proof that the defendant acted unreasonably with regard to the notice. And in this case, as had been discussed to some degree already, Walmart acted reasonably to keep its premises in a reasonably safe condition.
Well, and the evidence of that, don't describe it. Just, is it the affidavit of Mr. Pritt and the 30B6 discussion of Erica?
Yes, ma'am. Yes, sir.
Okay.
It's also the video footage which shows that it's in a good condition, that the contractor was on site going through the aisles. It was also the photographs that were shown. It was the plaintiff's testimony that she said she drove around the lot and she didn't see anything that caused her concern for her own safety. It was all of that.
And I hear, I think I understand that part of the argument. Is there, could a jury look at the video and say that the video evidence of the parking lot calls into question the truthfulness of Mr. Pritt's affidavit? Because for 2 hours, there's no evidence seen that there's any chemicals, any salt, or any scraping taking place. I'm not suggesting what happened or didn't happen, but could a reasonable jury look at that video and say, this calls into question to me whether Mr. Pritt and Erica were telling the truth?
I don't think so, Judge. I think that the evidence of that video and those photographs show that it was in a reasonably safe condition.
I know, but what they said, it may do that, and maybe that's your argument, but my question maybe is a little more specific, a little more preliminary. If Pritt and Erica say there was chemicals dispersed or salt dispersed, we have a video that goes for 2 hours where most of the in the area, at least where most people seem to be parking closest to the door, and we don't see any chemicals dispersed or any salt dispersed. Now, that doesn't mean they're not telling the truth, but it seems to mean either salt or chemicals were dispersed at a different time other than those 2 hours, in different places other than those locations closest to the door, or that they weren't accurate. And so I'm just wondering, in light of what we're looking at, is that enough question does that raise any question that we're not sure yet what they did in terms of fulfilling any duty?
Well, Judge, I think where we are in the case is on summary judgment, okay?
Correct.
So it was the plaintiff's burden to come forward with evidence that appropriate measures were not taken. Not Walmart's duty to come affirmatively and provide evidence to the contrary. Walmart's testimony and Walmart's evidence was, yes, we did everything we were required to do under Virginia law, and that parking lot was in a reasonably safe condition. This sort of, I'll call it speculation, that there was no pretreatment put down, that there was no salt put down, that it was not scraped. I mean, we only have an hour before in terms of footage. So the only evidence is, that type of evidence is totally speculation.
Well, the video is not speculation. We know, it's not speculation to look at the video and see what was done or not done.
Correct.
So, and maybe you're right, but Walmart's put in an affidavit and it's got testimony that I'm not sure 30B6 witnesses' testimony about someone else is evidence that can be considered or not under, if you want it for the truth of the matter asserted, maybe, that's a separate question. But Pritt's affidavit, if that's the basis of Walmart's reasonable response, it seems like, if we were to say, well, let's assume we had a Pritt, a month later said, I got pressured, I did that affidavit, it was a complete false. I mean, you would say there's a question of fact then, wouldn't you?
Well, but Judge, again, that's not where we are. I mean,
Okay, but I understand, but accept my hypothetical. If that happens, would you say there's a genuine dispute of material fact?
I guess I would have to, but that's not where we are in the
Of course, that's not
proceedings.
where we are, but I'm trying to figure out if evidence, 2 hours of evidence in the area you would think, if you put down salt and chemicals, that's where you would do it, calls into question that. And if it was earlier, which is certainly possible, that's 7:30, they may have done it earlier, and, you would think then you'd say, well, all you need is the contractor to say, I did a little short affidavit, and that doesn't mean that didn't happen. And it doesn't mean that you even needed to do any of that. I mean, I think you could look at a lot and it could look clean, and you could say, I called the contractor, they came out, they looked at it, they said everything looks good. Might have missed it, might have been wrong, but if your story is they put down salt and chemicals, and we have 2 hours where it doesn't look like they're doing it, does that not create a question of fact as to whether that occurred?
I would still say no, not at this particular instance of the case.
Okay.
Again, it's only an hour before, and that's really what we're considering in terms of the plaintiff's incident. I mean, the undisputed evidence shows that they were on site for hours before that.
Can I, what?
Wait, what is that
where's
evidence?
Yeah, tell me that evidence.
That was in one of the affidavits, I believe, or the affidavit of Ms. Pritt.
So that doesn't help me,
If
right?
I don't want to put
Right,
you on the
if you're
spot.
making a claim that you have evidence that the contractor was on site for hours, right? That's a representation you're making. Like, I need something more than it's in one of the affidavits somewhere.
Well, I may have misspoken in that regard. I mean, it was, I may have misspoken in that context.
Can I ask you
But I did want to address one
Yeah,
thing,
yeah,
Judge, I didn't
sure.
mean to interrupt you. But the evidence would be, again, there was a question asked about, well, what should they have done, maybe what should they not have done in terms of putting on, in taking care of the parking lot. That was their burden, again, to prove that even if, we had a contractor on site or the contractor wasn't doing what they were supposed to do, that it was in violation of some sort of industry standard. And that certainly, there was no expert.
So help me
put forth.
understand that argument. I understand, if Pritt had come in and given an affidavit that said, I walked outside and the asphalt was clear, I didn't think any chemicals or salt needed to be put down, the contractor agreed with me, I would understand that argument. But your expert, asset protection coach, Pritt, says that Walmart took action, that they put down chemicals and salt. And hypothetically, accept for a minute that I think the video suggests that he's lying about that. Just hypothetically. Walmart has taken the position that this is what we did. That suggests to us that that was what they thought was necessary, that your expert, your employee thought that that was what was necessary, because otherwise he wouldn't have claimed falsely that that was happening. Right? I mean, that's what Pritt says. Hypothetically, the video suggests that he's like being dishonest about that. That seems to raise a question that he thought that was necessary even though it didn't happen. Right? And so that's the standard that Walmart itself seems to have put forward.
Well, I don't think his testimony or affidavit states that it was happening in that specific hour right before that's shown on the video. I think he's saying that at or about that time, that's what was happening.
And it may well be at trial that he will then testify to that, and the contractor will say, yeah, I did it at 6:45, and I was done by 7:28, right? And why we just have video starting at 7:30 is a question, and jury can decide to draw that in your favor or the plaintiff's favor. It was your video. I don't know why you didn't provide it if it showed the very thing that you thought was necessary. But I totally get. You might well win in front of a jury. But what I've got to do is look at your proffered evidence in light of the video, and the video, except for my hypothetical, shows that your guy is lying. right? And what do I do? If that's hypothetically true, what do I then do?
Well, I don't believe he's lying. I believe he said, I mean, I don't think the video is that clear. I mean, it shows the truck going through the
But you
premises.
agree if it did, right? So this is the equivalent of Judge Quattlebaum's question earlier. If Pritt withdrew his affidavit, or if hypothetically I found that the video showed he was not telling the truth, you would agree there's a factual question
Well,
then.
even if we withdraw his affidavit, I still don't think the evidence is sufficient enough to prove that Walmart didn't act reasonably under the circumstances.
It actually would be, I think, better for you if you didn't have the affidavit, right? I think if you didn't have the affidavit, we could have a discussion about whether ice and chemicals needed to be put down, right? But it's hard to have that discussion when your own representative says, this is what's happened. And like a false exculpatory statement is evidence of knowledge of guilt,
Well, again,
right?
I don't think that he's making a false statement. I don't think it's, in terms of timing, says that it's happening during the video. And I'll go back to my question. I think it's their burden to prove that we acted unreasonably under the circumstances, and that has not happened in this case. The fact of even putting down ice or chemicals or sand or doing whatever they have suggested is total speculation. There's no expert testimony in the case or testimony otherwise that says, you know, this is what you do.
And your view is that Pritt's testimony that that was what was done, if false, suggests that that's what he thought needed to be done, right? That's the false exculpatory statement. And I get, you think he's a priest and everything, we can trust everything he says. I totally get that. But hypothetically, except for a minute, that doesn't seem to be the case. Hypothetically, right? And so he said this is what we need to do, and if he's lied about that, that suggests that he's the person that has put that at issue, right? Your own witness has suggested by his affidavit that they needed to put chemicals and salt down. Right? That's the evidence that that was what the standard of care was.
Well,
It's
Judge,
your witness.
number one, I don't think he can set the standard of care. Number two, I don't think that he's saying it needed to be done necessarily. I think all he's saying is that they were doing.
Not necessarily, but it's
they-
some evidence of it, right?
Yes, sir, that's what they were doing, that they were out on site doing those things.
Counsel, can I ask a slightly different question? One of the issues we have, and that the Virginia law talks about, you alluded to it earlier, is there's a certain period of time after notice occurs that a property owner has to remedy an unsafe condition. Does that issue apply here? I mean, assume we think Walmart doesn't have to know about that very specific patch of ice. Are we really have a grace period case here? I mean, you're not suggesting, are you, that Walmart had more stuff to do, that if we had just waited 30 minutes or an hour, which would have been a reasonable time for them, that there was more stuff to do, or do you?
No, sir, and we didn't raise that issue, and quite frankly, I mean, that is a correct statement of Virginia law that Mr. Hawkins sets
It's just
forth.
not really
But
applicable
It's
here.
not applicable here. We didn't raise the issue. Now, we don't concede the issue if the case had to have been tried.
I understand. One other thing, Mr. Pritt, I think in his affidavit says he went out and inspected the lot. Isn't that pretty accurate?
Yeah, he said he had come out, I think he said, just generally speaking, had come outside.
Do you have a view as to whether the video shows him coming outside?
I don't have a view on that. I'm not sure that it does, but I'm also not sure that he's saying I came out in the front of the store, in the front of the parking lot. Because again, as the court is well familiar, these Walmart stores are big. There are other areas of the parking lot that he could have been in.
And he's not saying when he did it. So just like the snow and ice or the chemicals and salt could have been done before 7:30, so could his inspection, and it could also have been a different location. My question was simply, is it your position that the video shows it depicts what he said he did in the affidavit?
I don't believe that it does, Your Honor.
I mean, it says, what he says precisely is, at approximately 7:30 a.m., which would be included on the video if it was true, I walked out, inspected the parking lot, and spoke with them, the them being a reference to the contractor in the previous paragraph, right? And so at 7:30, we see the truck, right, pull all the way through and not stop, right? I mean, there's two videos, right? We only have stills from one, but the video from the other. And the contractor that's there at 7:30, when he claims that he walked out and stopped the truck and talked to him, like, doesn't stop, doesn't, like, have an interaction with a person, right? Again, like, really plausibly raising the question about whether your guy is telling the truth at all.
I don't think he was saying that it happened actually in front of the store. Again, there were other parts of the store, there were side parts of the store.
Is there a parking lot in the back?
There are spaces, there are
So you
other
think when it
areas of the
says
store.
that no reasonable jury could conclude when he says that they were applying chemicals and scraping the parking lot as necessary. At 7:30, I walked out, inspected the parking lot, the one he just said was being salted, and spoke with them. I also requested that they be sure to salt the parking lot areas on the side of the store, meaning not where he is, right? No jury could conclude that that's referring to the parking lot in front of the store that he's asking them to salt and chemical.
That would be our position, Your Honor.
Okay.
Can I, just before we let you sit down, I just had one other question about Mr. Pritt. So am I remembering right, this is the declaration that was attached to a brief?
Yes,
It didn't
ma'am.
come out in discovery, so no one's had a chance to
Well,
depose
and Judge,
Mr. Pritt.
it's not, I don't know that it's necessarily in the record, but his name was provided at the very beginning of the case. The decision was made by plaintiff's counsel not to take his deposition or not to deal with him. I mean, that,
So you can do that, just attach an affidavit to your brief on some, it was your reply brief,
Yes,
right? So
ma'am.
case is over, there's like no chance to ever depose him,
yes,
or?
ma'am. Well, even if
He could have-
we had submitted it on our initial brief, that was okay. They wouldn't have reopened discovery in terms of taking depositions or anything.
Well, and and just to play that out, I mean, let's assume it was someone who hadn't been disclosed. I mean, that might be problematic for you, but a district court might say, well, I'm going to allow it and I'm going to let the guy take his deposition, right?
Perhaps, Judge, I don't know. That's speculation again, but
Well,
here's.
that's just how the real world works.
but
I mean,
here-
I'm not saying that's bad for you. I'm just saying you put it there. If the guy didn't have a chance to take his deposition, if your colleague didn't have a chance, he could have asked to, and the district court could have looked at that.
He could have, but that did not happen. There was not a motion to strike filed. This is on appeal, is the first time that issue has been raised, and we think it's inappropriate for the court to consider it at that time.
The plaintiff's lawyer might have decided that it's the best evidence that he has, right? I mean, he might have looked at it and said, having the Walmart guy lie about what happened is actually the best affirmative evidence that he has. And so if he struck it, he might well lose.
Maybe he made that decision. I don't know, Judge.
Thank you very much.
Thank you.
Mr. Hawkins, I think you have rebuttal time.
Thank you. Sorry again about the voice. I would suggest to the court there's one Virginia case that clearly says what the rule is in a snowstorm case. It's the Mary Washington Hospital case versus Gibson. It's cited at page 13 of my reply brief. In that case, it's a snowstorm case, and the court instructed the jury, the trial court did, that the owner of the premises had a duty to use ordinary care to remove ice and snow within a reasonable time. And then it added, after it knows about the use of ordinary care, should know that it is there. Now, those are the words from the foreign substances instruction. The Virginia Supreme Court reversed and said that was not the law, that instruction should not have been given. And I'm going to read from, I think, with page 6, it's on my copy of the case. The court said, and I quote, "If, however, a reasonable time had passed after the end of the storm, as the plaintiff's evidence showed in this case, it became the duty of the hospital to use reasonable care to remove natural accumulations of snow and ice from the areas used by its walkways." And it cites Langham Road Apartments, Kings Market versus Yates, and then the court says instruction 11 should not have been given. So clearly in that case, the Virginia Supreme Court said once a reasonable time has passed, and they have the opportunity to clear. From that point on, no specific notice that a dangerous spot is there is not the law. And rather, the law is the question, did they take reasonable steps? The Langen,
Can I ask you a question about
Yes,
this
ma'am.
PRIT declaration that we've been talking about so much? You sort of allude in your brief to the idea that, well, this just popped up on their reply brief. It wasn't part of discovery. But
Right.
did you not want to depose Mr. PRIT? Did you ask for time to depose him?
we didn't because the Walmart representative who speaks for Walmart said, we have no record of anybody inspecting. We have no record of anybody doing anything, putting down snow, or putting down chemicals, anything else. Okay, so we don't believe there is anybody that's going to say that. And of course, then this pops up, which was a surprise to us. Had his name was delivered in discovery as a person at the store, but nothing was said about he had any knowledge of these things. When Walmart itself says we have no record of that, we thought there wasn't any.
But that gives you the right to move to strike it, and you didn't move to strike it before the district court, correct?
I kind of like what it said because it puts them on notice.
I
It
got
puts
you.
them on notice.
Well, I don't disagree. That's fine for you to have that view, but you can't say, I mean, Judge Harris, I think, made the point that, you know, your brief almost makes it look like we shouldn't consider that affidavit because it was too late. And your position is perfectly fine for you to say, it may have been late, but I liked it, so I'm not complaining about it. But it's kind of odd to say, on the one thing I think is the greatest thing in the world for my case, on the other hand, I'm a victim of a late affidavit. And the law, I mean, you would agree with me. I know you've been in trial courts a lot. I mean, if you get a late witness, that happens in real life, and some judges may say it's too late, I'm not going to allow it. Some may say, hey, I understand it happens, and I'm going to extend and let you take a deposition. All that, any of those scenarios could play out, and sounds like you like it, so you just sat tight.
May I say, as a trial lawyer, I like to keep my options open.
Well, I get it, but you got it's a little bit, you can't, at some point, you can't play inconsistent cards.
I
That's what
agree.
it seems like you're doing.
I agree, Your Honor, and I think it's, what's the term, not approbate and reprobate. Maybe I am doing a little bit of that.
Can I ask you two questions?
Yes, sir.
Factual questions. Your colleague said the contractor was on site for hours. Is that, I'm asking because you know the record better than I do. Is there evidence of that?
Not a bit, no. The only evidence is that video.
Well, and some testimony that they were there at 7:30. The court seems to think they were there at 7:30. That's
What?
both based on the video and Pritt's statement that he spoke to him at 7:30.
Yes, sir, and the video is at 7:30, 7:31, yes.
Yeah, okay.
But, I mean, are you through?
Can I ask one more question? Sorry, there was a second one.
Yes, sir.
There seemed to, in different conversations we've had, we sometimes referred to the contractor being called, and sometimes the contractor just showed up on its own volition. Is there evidence one way or the other in the record as to whether Walmart contacted the contractor that morning to have them come, or whether the contractor came by virtue of the contractual relationship without a direct call from Walmart that morning?
I don't believe there's any, at least to my memory, that there's anything in the record either way.
Either way, okay.
Just to follow up on the timing issue, I understand your response to Judge Richardson's question. There's nothing in the record showing that they were there before 7:30 when the video starts. But there's not a position Walmart's taken that would be inconsistent with the fact that they got there earlier and had already done some work. I mean, in other words, that if we, if we rule with you on appeal and he goes to trial and the contractor's called and says, yeah, I was there at 5 and I put all this ice down and I did it in this systematic way, is there anything about this case that would be a problem with that being part of the evidence at trial?
Well, of course, that would be something new. I guess not. But I note in the Pritt affidavit, he says that he viewed the video, and that the video, that is the contractor.
Right.
So that's at 7:30.
Yeah, but I think I saw something that they keep video for a certain amount of time based on document retention, which, that they're not representing this is the video, represents the total time he was there necessarily, is all I'm saying.
No, but that's all the video they were able to produce for us. So
Right.
I think if they wanted to say something else, we'd have a spoliation, perhaps, argument. But this is all we've got.
I got
That's
you.
what's there.
I've gone outside the record more than I
Thank
need
you.
to.
Thank you very much.
I'm fine, but I'm glad.
Great, we're going to come down and greet counsel, and then we will hear our third and final case. We'll hear argument in number 23-2246, Elam versus Early. And Mr. Goldman, whenever you're ready.
Thank you, Your Honor. May it please the court, my name is Robert Goldman, and I represent the appellants in this case. This case, I believe everyone will find to be fascinating.
Just,
It's a case that involves, go tell them to be quiet.
sorry, we'll make sure you get your time back. Just want to make sure we can hear.
Thank you very much. It's a fascinating case because it's a case that involves history, it involves art, it involves 100 years of jurisprudence by the District of Columbia as far as inter vivos gift law is concerned. All those converge in this case to make it very compelling. Yeah, I believe it boils down to something fairly simple. The question in this case, and perhaps, I believe the court's probably aware of the background on this case. Okay, thank you. Is whether or not a grandfather Early, when he died intestate, prior to dying in 1951, did he make an inter vivos gift of artwork from Norman Rockwell to his daughter in 1949?
Can I actually, I hate to interrupt so early, but I do want to ask a question because I'm not sure why that is the question in the case, and I want to give you a chance to explain. So at some point, and it seems to be undisputed, Helen had possession of this, of the illustrations, which would seem, at least, to give rise to this presumption that of ownership that comes with possession. And so at that point, isn't the burden on you to show that your clients actually owned? I mean, I'm not sure it matters anymore how Helen did or didn't
Well,
get
yes.
possession.
I believe it
Because we're
does.
assuming it was lawful.
I believe it does, Your Honor, because somebody can have possession that, of objects which are owned by multiple people. People can have a possession by.
So you're saying the presumption should not apply?
Well, I don't think you get to the presumption if there was no gift. And
I don't under,
let me explain that if I
Okay.
could. In this case, we have admissions by the appellee, which leads to, I believe, it's the foregone conclusion that there was no inter vivos gift.
fine,
And
what if I,
that's-
okay, go ahead.
I'm sorry.
No, you go, tell me.
Okay.
If that is true.
Yeah, and if that's true, it doesn't matter, because in 1951, if that's true, then by intestacy law, the sons and daughters receive 2/3
Well, that's
of the
if
artwork.
they're still in the estate. even if Helen didn't take them by inter vivos gift, how do we know they're still in the estate? There's an estate accounting and it doesn't have them.
Well, there's many reasons why it might not be in, well,
Right.
first of all.
And that's the point of the
but-
presumption. It's very
but-
hard to go back and figure out what happened
Yeah, but it's
back
not
then.
hard in this case, Your Honor, that's the whole
Why
thing.
not? Maybe,
Well,
you know, I came up with one just off the top of my head. Maybe the grandfather gave them to the grandmother.
I
And
haven't
then the
mentioned that-
grandmother gave them to Helen. Who knows?
No, but the appellee never claimed that.
Doesn't have to, has the benefit of the presumption. You have to come in and explain why your clients actually own it. You have to provide evidence of superior title. And we've said in our cases, it's not enough to call into question the title of the person who had possession. You have to show that you own them.
Well,
Or, I'm sorry, you have to show that your clients own them.
but at the same time, the duty is upon the donee who's claiming the gift to show clear and convincing evidence that there was a gift. And, Your Honor, respectfully, if they acknowledge that Helen never took possession of the artwork until 1960, if they acknowledge that they had no evidence of the gift otherwise, if they acknowledge that grandfather Early was still in possession of the artwork when he died in 1951, as a matter of law in 1951, the intestacy laws come into play. And at that point in time, before Helen Elam ever comes into possession of them, they're distributed in 1951 by operation of intestacy law. And so in 1951, automatically, the sons and daughters become 2/3 owner, and the grandmother becomes a 1/3 owner. And then, going down the sequence of what takes
So
place.
given that, under that theory, I guess, I had a bunch of questions, but can I start with the question of the possession from 1960 to 78? It seems there's a factual dispute as to whether the mother or the daughter was in like actual possession for much of that time. There was a point in 69 where I think she had it, but it was the mother's house.
Right.
It would be odd to think when the mother goes to the hospital that the mother's house then becomes the daughter's possession while she's still alive. It seems like the things in the house remain the mother's, in the mother's possession. The fact that she's in the hospital, I mean, if you put me in the hospital, all the things in my house don't become my wife's immediately, right? Like they.
Well, I would hope not in my case also, that if I go into the hospital, for whatever reason, and I collect Teddy Roosevelt items, and I go into the hospital, no relative of mine owns my collection. They're mine. I'm still alive. I'm still kicking.
And you're still effectively in possession of them. 'cause
You
they're
are in possession of
They're in
them.
your house.
Yes.
You were in a hospital bed,
Right.
but they're still in your house.
Right.
You have possession of them.
Absolutely.
So I guess the question is, why do we think, you talk about 1960, that Helen had them in 1960, but it seems like to me, Mama had them in 1960. There's a debate about a little period in 1969, I totally get that. But then they returned to Mama in whatever year it was, 72. The
78.
years run together,
I'm sorry.
right?
Yes.
But, so that means that at least for most of the time period between 1960 and when it goes to the White House, like, Mama's got it,
Right.
not daughter.
And under the presumption of possession, if they're arguing that since Mrs. Elam was in possession at a certain time later, well, why don't we give the presumption of possession to grandfather Early, who had it
But that's
in
not, is
1951?
that how it works? That's an interesting question. I thought about that. We would have, but the presumption doesn't divest, as I understand it, it seems to me the presumption, applies if someone in possession claims ownership. The fact that we may have shown possession by someone else doesn't mean we don't, I don't think, apply it now. In other words, Grandma Early could have claimed it and would have gotten the benefit of the possession during the time she possessed it. There's a question of whether she did or whether it was Helen's and she went to live with them. But maybe I'm wrong about this, but does the fact that the presumption might have applied earlier, is there any law that says we don't then consider it later in time when someone else possesses it?
No, I mean, obviously you can consider it.
Adverse possession
but-
changes title,
Right.
but this is just a presumption
Right.
that then you go and have the ability to produce
Exactly.
superior title.
Right, and that's why I think this goes back to what Judge Harris was talking about. It's a rebuttable presumption. It's called a rebuttable presumption. So Helen has it, and we rebut it by saying, but no, she's not the sole owner of it because of the intestacy law. She's not the sole owner of it.
But that's a, I hear you, so let's talk about that. Sounds like you're saying the presumption applies, and the question is whether you've rebutted it showing superior title. Is that, am I
You're
correct?
missing one step. I contend, first of all, since they've acknowledged that the elements of the gift law in DC were not met during the lifetime, as a matter of law, that was distributed in 1951 under intestacy law. Secondly, they claim the presumption, and then we argue if you're going to apply that presumption, it's rebuttable, and we rebut it by our evidence of what happened up to 1951, and we rebut it because of it being at grandmother's Early's house, according to our testimony, all the way from 1951 to 1978 when she died, that entire period of time, except for a short period of time because of water damage in the basement of the house. It went into Applee's mother's house.
Can I follow, yeah, I don't mean to cut you off, but I'm just trying to,
That's
so
right.
I just want, and I get your first argument. That seems like where you've put most of your eggs, is that we don't have to do the presumption because of the absence of an inter vivos gift. And that's kind of a legal question of, I got that, don't want to, I'm moving past that to your, it sounds like your alternative argument that you've shown superior title. And when I looked at the briefs, I didn't see how you proved that. It looked to me like your position was all that first argument. You have a discovery response where you have a lot of stuff about representations and that Helen made and that questions were asked by these folks or not, but I don't see any of that in your briefs on appeal or below to say that's how we showed superior title. Am I right about that?
I'm a little confused, Your Honor. I missed the import of the latter part of your question.
Yeah, I'm sorry. When I read the record, I mean, I read the discovery response that talked about various things that Helen had said to her siblings and maybe to her nieces and nephews, and that, had been said to, her sister-in-law and various people in the record. But it didn't look like you argued all that indicates superior title to me before the district court or before us.
Well-
It looked like your superior title argument was hook, line, and sinker to say there was no inter vivos gift.
I believe you're correct that is it was what we consider to be a rock-solid winning issue.
Okay.
But aside from that, we did deal with a rebuttable presumption, because we did put evidence in there that, according to the appellee, the mother came into possession in 1960. According to our witnesses, short period of time in 1969. And then the grandmother dies while the artwork's at her house in 1978. So in 1978, we've rebutted it because that evidence, at least to go to the jury, if
So
not.
I thought your argument earlier was the evidence you put on of your title is the gift from Rockwell to Granddad, right? And then Granddad dies intestate, and so by action of law, intestate goes to the three folks, right? And, well, I guess the three kids plus grandmama.
Yes, sir.
Right? Grandmama maintains from 1951 on, she maintains the painting.
Right.
And so then it passes by virtue of wills to the various people that play. That's
right.
your evidence of title.
Right.
And then so you're not just calling to question theirs, you have your own affirmative evidence of title. And in addition, you then show why it's better than theirs because you attack their argument as well. But you're not just attacking their argument, you have your own evidence of title.
Thank you for doing a better job than I
Well,
did.
can I ask you then, because the district court, at the end of the opinion, and I was wondering what you made of this, after the presumption discussion says, in addition, I've looked at all the estate documents, I've looked at everybody's will, I've looked at the estate accountings, and those documents show, and I think the district court says conclusively, that Helen owns it, because it's not in the estate accounting, it's not in any of the wills of the people who died with wills where you would expect to find it. There's no explanation for why it wouldn't be in any of these documents. The only person in whose estate documents it shows up is Helen. So I'm looking at that evidence, and I see that Helen has superior title.
Well, in 1978, when grandmother Early died, her will says, I give my objects of art to be divided amongst my 3 children. I hope they get along and can figure out a way to deal with
Is that the
this.
stuff that was valued at $3,000?
That's correct. And I also went, for you to take judicial notice, you'll find out that cars at that period of time were selling for a few $1,000s. And
In 78? Is that when that is? Isn't that?
that's
that-
1978.
Yeah, and, okay.
That's 1978.
So your position is that the part of, it's not, her will is kind of general, it doesn't lay out all the assets, but we have the detailed acknowledgements of that are in there. None of them mention the art, right, specifically? None of them mention the Rockwells?
Not by title, no.
Yeah, and so, you know, your argument is that reference that totals $3,000 covers these pieces of art that y'all have argued below and are up here on the Fourth Circuit arguing now and paying lawyers to do this much.
But I think what's really important about this is there's no law cited by the other side, and I know of no law that says if somebody doesn't in detail list their assets in the estate property, you forfeit that property.
Yeah, that's completely fair, but you would think if your argument is that they went intestate to Helen and the kids, and then and then when those kids died, you would think their wills might have mentioned them. And they don't.
No.
I mean, they
Well,
don't
one
say,
died
look,
in-
I got a third interest in these very valuable Norman Rockwells. Stevens don't, Thomas's don't.
One died intestate. So,
Okay.
yeah, one died intestate, but
I thought you'd just say, you're right, that's evidence that cuts against us. And, you know, we think at some point,
Well, a
some
jury
fact
decides
finder is
it.
going to have to determine that.
yeah, a jury decides that. If
We got evidence this way, they got evidence that way, what do we do with it?
Exactly. And
But if-
the reason why I think we're entitled to a jury to decide that is because there's no law that says that people who fail to put things in detail, I mean, I think it's common sense that a lot of us who have had parents die, I leave to my children all my personal belongings. That doesn't mean
But
that,
I thought the grandfather's estate accounting was really actually very detailed and specific, and that's why the district court thought, like, it just didn't make any sense that it would be missing this one object when it had gone through in great detail all the other
but there's
objects.
also, we're getting into conjecture here because there's also, for what we could, if we're guessing at things or surmising,
Well,
which is
I'm
what-
literally just,
No,
I
I'm not
want
saying
you
you
to
are, Your
address
Honor.
what the district court said.
Yes.
That's sort of
Well,
how
I
I
think
started my question. What
we-
do I make of that second part of the opinion, which seems to be independent of any presumption, where the district court just goes through the estate documents and says, not only can you not rebut the presumption, but your argument is rebutted by the documents.
Well, it's not, I respectfully say that it's not rebutted by the documents. It's not supported by the documents, but the absence for tax evasion.
And you think you can
for-
rebut the presumption even though the argument is not supported by any of the estate documents.
Right, for everything else that we already discussed.
And that is, again, that
Is-
is the absence of the inter vivos gift.
In the absence.
That is what rebuts the presumption. It's not any of the estate documents. It's the absence of an inter
Well,
vivos gift.
there's also things that rebut it. There's a conversation between son Stephen with the appellee and his mother Helen.
But you didn't argue that,
Right,
we,
that's-
maybe you make that now, maybe we consider it, but you didn't brief that.
I did, Your Honor.
What, will you?
Where?
Well, on rebuttal, will you show me the page where you argue
I will, Your Honor.
those things?
Yes. Yes.
All right, we've run you way over
Yeah.
your time, so, and you have rebuttal time.
Okay. Thank you very much.
May it please the court. My name is Philip Harvey, along with my colleague Paris Sorrell. I represent William Elam in this appeal, and we ask that the court affirm the decision of the district court. The issue, obviously, is who owns the Rockwell illustrations. There are 4 of them. The Virginia Supreme Court gives us the framework to follow to make that decision. In the Maine versus Adams case, when a dispute arises as to who owns personal property, the court tells us to look to possession as prima facie evidence of ownership of the property until better title is proven. And this common law presumption of ownership based on possession requires that the party not in possession of the disputed property produce evidence of superior title. So once my
So
client...
can I stop you there to talk a little bit about the presumption?
Yeah.
So I don't see anything in Virginia on this, so I want to concede that up front. But when I trace this possession as being prima facie evidence of ownership, right, or a presumption of ownership, the record suggest, the case law and history of that suggest it does not apply to jointly owned property that cannot be physically divided, right? Because the possession in that instance is not inconsistent with the joint ownership. So the Supreme Court describes it and says that possession is evidence of some kind of rightful ownership or title. And so, yes, I want you to respond to, yes, a presumption shows that Helen had some rightful ownership or title, but it doesn't show or doesn't apply or doesn't give any presumption of absolute or sole ownership. It just shows that she's an owner. And that each case that Virginia has applied this presumption is a case in which the possession is inconsistent with the alternative claim of title, right? That these are 2 titles that have to be inconsistent. But the other courts, so when you look at other places like Missouri and Illinois and the U.S. Supreme Court's own description of this venerable principle, it doesn't suggest that it applies to jointly held property that cannot be physically divided. Help me understand why you think Virginia would adopt a broader presumption than seems to be in the common law.
Well, first, you look at the language of the Virginia cases, which obviously don't make the kind of exception you're looking for. And then you look to this case.
But you agree, they don't address that, right?
That's right.
Yes, it is true that everybody says, possession is 9/10 of the law, right? The version of that here is that possession is a presumption of ownership. And that is true. I agree with you that her possession, if it's true that she possessed it from 60 to 78, and we can debate that, but it does provide a presumption that she had an ownership interest. I
Yes.
totally agree with that. But does it show anything about that ownership interest being absolute, sole, as opposed to joint? And that's the trouble that we have. It comes up in marriage cases. It comes up in all kinds of contexts where you have joint ownership of physical property that can't be divided. I agree, I've not yet seen Virginia deal with it, but it seems odd to suggest by silence that Virginia has expanded the sort of common law rule.
Well, I don't know that the common law rule, I mean, I haven't read the cases from Missouri and wherever the court's discussing. But in this case, when the issue is possession, I mean, my client and his mother before him had sole possession without a peep from anybody.
But I understand that, but mine's a theoretical point, right? So I'm conceding for purposes of this discussion that there was sole possession, right? But it's not inconsistent with joint ownership, right? Because nobody thought that what we ought to do is get out a pair of scissors and divide this painting into 3 parts.
Right.
Right? This isn't like corn that we could just like divide up. Everybody gets their like pro rata share.
Sure. I mean,
Right?
what-
This is a single item. And even if everybody agreed that it was joint possession, somebody's got to have it.
Sure.
Right? And so in that context, why do we think that there ought to be any presumption based on any one joint owner's possession? That's what I'm trying to get at.
All I can say is the cases in Virginia discuss possession, they don't discuss this exception. And beyond that, I don't have a reason for the court to come to that conclusion.
But that, I mean, it's an interesting question, and as I have looked at some of it, and certainly I don't profess to have a complete, understanding of all the historical analysis. It might apply, that the quote exception, if that's what you call it, might apply with greater force if you have property that on its face is jointly owned.
Right.
Like a note that's payable to
Sure.
2 people. Then possession of a note that's payable to 2 people, be pretty hard to say my possession of it gives me some leg up. I'm not saying that's the only situation when that historical exception applies, but, if you take that further, and maybe that's where we go, it would, it would give the non-possessor who claims joint ownership a substantial advantage in overcoming what people use in a whole lot of cases to establish at least a tiebreaker.
Sure, the non-possessor could just say, oh, I own half. Therefore, these presumptions don't apply, go prove it.
Can I,
And that's the problem with coming up with a claim that you own property after having been silent about it for at least 4 decades.
does, I also had not read the Missouri cases, but did this come up before the district court? This
No.
question? Okay.
No, this
and
was not argued.
This was
There
4 illustrations, right?
What? Yes.
So no one had to
There-
cut any paintings in half?
It's a panel. If you put them next to
One
each
piece
other,
of
it looks like a continuous
They all-
scene
It's one.
across the 4 illustrations.
Okay, sorry. Okay.
Um, But the point is that the defendant's arguments below were, forget the presumption, doesn't matter. You have to prove that there was a gift in 1949. And we said, we can't do that. We can't come up with donative intent by a man who's been dead for 70 years. But we don't have to. You do. You've got to deal with that, not us. All we-
I want to interrupt you, and we've read your brief, so I don't think the fact that I'm interrupting you doesn't
Go
mean
ahead.
we don't understand your argument. But I'd like you to respond to what your colleague seemed to accept was an alternative position, which is, okay, the presumption applies, at least, arguendo. We've established a genuine issue of material fact of superior title by virtue of the gift to Grandpa Early, and the fact that he died intestate. And I guess the fact that Grandma's will didn't specify anything. Does that, and I may have left out some part of that position, but what's your response to the question of, well, that's at least a genuine dispute of material fact on superior title?
No, it's not. They have to try to prove superior title.
Well, but they say that does that.
Right, But what they point to is, you've got to prove, they say, we have the burden to prove about a gift. We do not.
I got that argument.
Okay, so then they go through title.
Well, hold on, just let me frame the question. So there's this first question of whether you have to prove it or not. You're welcome to keep arguing that. I'm not as interested in that.
Okay.
What I'm interested in is your response to their position that we accept we may have a burden. We disagree, but we're conceding if that's true, we've maybe not established it once and for all, but we've overcome the rebuttable presumption for purposes of summary judgment.
They have not, because other than talking about the gift, they effectively offered nothing. The estate of grandfather Early did not, who died intestate, did not include the Rockwells, although they were so important. And the estate, the inventory got
But
down to.
whether the estate included it or not is a legal question. It may be that the documentation did not include it, but whether the estate included it or not
Right?
is
a
a
legal
different question from whether the documentation included it or not, right?
That's right. That is a different question. But evidence of what these people thought and what the facts were, it tends to derive from the estates.
And it may tend to derive from it. I understand that argument, but that's a factual debate, right? We can have a question about whether it's inclusion or not, cuts one way or the other, but the question is, why is that not a question of fact for a fact finder, which might end up being the judge anyway, but put that aside.
Because on summary judgment, they've got to do something more than speculate. Yeah,
Well,
maybe they
but
left.
they're not speculating at all, right? This is the question that Judge Quattlebaum asked, right? The evidence that Judge Quattlebaum gave you, why is that not sufficient to raise a question of fact as to who has superior title? They have a title story, you have a title story, right? And so now they put forward affirmative evidence, you have affirmative evidence, but now we got to decide which one of you is correct.
But their affirmative evidence doesn't show anything about title. You say that the estates may in fact legally have included the Rockwells or interest in the Rockwells, even though they don't show it. Well, they've got to come up with some evidence. And what they have is a series of estates, none of which mention the Rockwells. Grandfather's doesn't, grandmother's doesn't, and the two brothers through whom they claim, their estates don't either.
And isn't that the point that this story that they may have,
Right.
dying intestate doesn't cut one way or the other? I mean, they can use it, but it's not inconsistent with the gift necessarily either.
Sure,
That-
it is
that
inconsistent.
what they have, your argument seems to be, yeah, they got a story, he died intestate, the wills may cut against me, that's a genuine dispute of material fact. The response, I guess your response is, that's not enough to create a genuine dispute of material fact.
That's nothing. They say that the gift was
All right, so
made-
what do you then do with Grandma Early having it from 51 to at least 60, right? Because that is consistent with the notion that it passed intestate, right? The fact that Grandma kept it, right? This is the whole point of the inter vivos gift, but I'm not trying to make that argument. What I'm saying is, it's not that there's nothing in the record that suggests that it passed it intestate, right? Because it then went to the person we would think it would go to if it was Grandpa's to begin with, his wife.
Well, if it was grandpa's to begin with and passed intestate, his wife only got a third. The kids collectively got two-thirds.
That's correct, but it's one piece of art. And whether, Judge Harris might be right, it's multiple panels, but it's one piece of art.
Right.
You wouldn't naturally take, a multiple panel painting and divide it into pieces and
Right,
spread
of
the
course you
pieces
wouldn't.
out, right? It's much more valuable as a single piece of art than it
Right.
is multiple. Grandma gets it.
But that's also consistent with the allegations that were made and backed up with an affidavit that after the gift was made in 1949, there was a recognition that the recipient of the gift, the daughter, didn't have a place to put these things.
And you might be right. Like, the point is, okay, that's your evidence, that's his evidence, right? A fact finder gets to figure that out.
Right? But
I just, and I'll ask both, I have lost track of where we are in the argument. Are we assuming now that there's a presumption?
Yes.
Okay, if we're assuming that there's a presumption, why isn't your answer, like, maybe if we were starting from scratch, like, oh, who knows what happened? That goes to a fact finder, but how can who knows what happened defeat a presumption?
That's right.
What
I mean,
work is the
that's-
presumption
That's the
doing?
point. There is a presumption, and they have to do something more than say, well, a lot of things could have happened.
Totally fair, right? And so a fact finder would have to say, there's a presumption here, right? But still, they get to determine, did they overcome the presumption, right? And so that's the factual question. The bar is a little bit higher, right? The tie
Right.
goes to the runner, right? I get that.
And the district court looked at all the evidence.
Well, he didn't look at all that, he looked at all the evidence that they presented. I
Right,
think you're.
Summary judgment, that's
At
the
summary
time to-
judgment.
That's the time to fish or cut bait. If you don't have the evidence on summary judgment, you lose.
Well, I agree with that. And so I think they have to have done enough to overcome, to show superior title. And we've been debating that a little bit as to whether
Right.
that, whether they've done that or not, whether they've, created a genuine dispute or not. Your position is they haven't, and I take that to be the case, or I take that, I understand what you're saying. I have a record question.
Yes.
I've read the briefs and I've reread them to try to make sure, and maybe I'll get some illumination on rebuttal about the argument of information that's in the interrogatory response.
Yes.
Where the Earlys list a lot of stuff that happened through the years and statements and things like that.
Yeah.
At summary judgment, aside, was affidavit or deposition testimony of any of those conversations, was that produced?
Yes, there was deposition testimony, but it doesn't support what the defendants say it does.
So, yeah, I
In
mean,
1960, there's a letter where Mother Early, plaintiff's mother says, my mother gave me the Rockville drawings in 1960. And our affidavit said that she had them in her house on Marlin Drive in 1960. They then say, well, in 1969, there's an issue. That's the hearsay recollection 50 years later of someone who was 7 at the time, who has no personal knowledge, who said first, do you remember what happened in this conversation about the paintings? And he said, no. And then 2 pages later, he gives this discourse about what was said, which all goes to moisture. It doesn't talk about he has personal knowledge of where the paintings were. It doesn't say that. This is a 70-year-old kid.
I asked a bad question. I'm cutting you off at your answer to my question. So, who I don't want what they said. Who testified in their depositions?
It's Michael Early was the one who testified about what happened in 1960.
Okay, and at the time of discovery in this case, the children of Grandma and Grandpa had all died, isn't that right?
Yes.
Had their wives, had Patricia, who was married to Thomas, died?
Yes, they were divorced.
Did she testify?
No.
Okay, that's
The-
all I don't have
The
any other
wife who
questions.
was still alive was Suzanne. She's a
Right.
defendant, but she's suffering from, I think, Alzheimer's, so her daughter, Andrea DeLeon, as a power of attorney, signed things.
Okay, I'm sorry to get you off track, I just wanted
That's
to
okay.
understand.
And so, in 1960 to 1978, I mean, the court said, I'm able to find, from 1960 to 1978, she has possession. In 1969, Mother Early moves
Do you
from...
agree with this idea that if I live in my house and I'm sent to the hospital, that whoever happens to be living in my house at the time now takes possession of all of my things?
No, but they were hers to start with.
But that like assumes the answer, right?
No, it doesn't. Mrs. Elam, the plaintiff's mother, my client's mother, moved from the Marlin Drive house to Hoover Lane in 1969, and brought the paintings with her, moved in with her mother in her mother's house. That doesn't make them her mother's paintings. She moved in with her mother. When her mother moves out because of the stroke in 1972, that doesn't
And this is
change-
your argument that she had them from 1960 to 1969
No,
or 8, whatever it is.
69 in her house,
And-
yes.
And you think that evidence of that is uncontroverted? right?
Yes,
That
they
there's
don't
no
contradict.
factual dispute.
There's
that-
nothing they
That
say.
she had the possession of the paintings living in a place without her mother.
Yes. And in 1969, there was this conversation. They say places them someplace else, but the court properly disregarded that as hearsay. And their answer is, well, it goes to the grandmother's state of mind. Well, grandmother's state of mind is not an issue. And that's the ultimate fallback, Your Honor.
And is and I'll ask your colleague this, is there evidence of that conversation, Michael's recollection of it?
Michael's recollection, he was a 70-year-old boy at the time, and 50 years later, first he says he doesn't remember anything, and then he says there was worry about moisture. They said the paintings were in the house. He doesn't say how he knew that. He doesn't say he had personal knowledge. Just as a 7-year-old, he said grandma was worried about moisture.
Right, I understand.
And it was all disregarded properly by the district court as hearsay. And so they stay there in the jointly residing house, but that doesn't mean when you move in with your mother, she doesn't assume ownership of what you bring with you. And so they stay there until 1978. In 1978, they're loaned to the White House, and they stay there for the next 40-plus years, and nobody on the other side says a peep. Nothing. For 40 years. They stay there. Nobody says a word. When when Thomas Early sees them in 2017, he still doesn't say anything to Michael.
Just so I'm sure that I follow this, I understand their evidence between 60 and 69. What is your evidence that Helen, who I think you're calling Mother Early?
Right. Mother Elam, sorry.
Elam, sorry. Whichever one it is. Let's call her Helen, so I know who she is. That Helen had possession of the panels in a residence that her mother was not in from 1960 to 1969? What do I look to for
I
that?
think it's a declaration of Mr. Elam.
And how does Mr. Elam know that?
He was the kid, he was there. Some of it's
So we're
hearsay.
disregarding one 7-year-old kid and accepting the other 7-year-old kid?
No, we objected
He was
to their
12?
evidence. They didn't object to anything we offered, nothing.
But
The rules
what
of
you're saying
evidence-
is that I have to look to, I just want to make sure I understand. What I'm looking to for your evidence is Mr. Elam's testimony as a kid that the panels were in his mother's house at a time when grandma did not live there.
Right,
And
and
can you, by any chance, I'm not trying to hold you to this, any chance you can tell me where I can find that in this record?
I don't have the page number in front of me. But the other thing
I
is
can
the
find it.
letter that Mother Elam wrote to the Rockwell Museum in 1960 that said, "My mother gave me these illustrations."
But you get why that's like inconsistent with your story? I think that's a great example, right? So, yes, but if that's true, that suggests that Mother Elam got the paintings in 1951 so that she had title to provide them in 1960, right? And that is inconsistent with your story, right?
Right. It's
I mean,
also-
that's an alternative argument. You might claim, I got them from my mother, but that's not been the argument that you've made. So if we look at that letter, that letter helps the other side, not you.
No, I think that letter helps me because the other way to look at it is that letter is consistent with the illustrations going to this woman as soon as she gets the house where she can put them up. And she says, my mother gave them to me. Her mother, in fact, did give her the paintings. Here, you take them. You take them. It wasn't like a donative intent. It was, I've been holding these things for you. Now you take them. But the
All right,
point
so
is,
a jury could buy that story, but it seems like a jury could well read the letter a different
right, but
way.
the issue of possession of these things and inferences, this is going to be a non-jury trial for that part of it. The common law claims are gone for a variety of
Maybe.
reasons we
So-
haven't discussed.
So can I ask that final question? Sorry, with your indulgence. Hypothetically, I get, but except if we disagreed with the grant of summary judgment, and it went back, could the district court decide to try the jury trials, the jury claims first? Because the jury has a right under the torts to decide ownership. And then the quiet title action, which is a judge question, he could take advice and counsel from the jury on that question?
He could. I mean,
It's not necessarily a judge question.
It
It
can
could
get
be, but it need not be
It did
given
get
the
tangled
order.
up with the Ross versus Bernard and
Right,
jury
okay.
judge. But the common law claims, for a variety of reasons, they're all gone.
I
Statute of
understand your arguments
limitations-
on those. I wasn't trying to raise those. I just wanted to make
Right.
sure that
So
depending
when
on.
they're gone, on remand, there's nothing but a judge trial. And it's going to be the same judge, looking at the
But-
same facts.
Just, and I'm sorry to go a little longer too. I mean, the judge also could ask the jury for advisory verdict. So,
Sure.
I mean, so I don't think, but it seems to me your argument that the same judge is going to decide this if we were to hypothetically send it back
Right.
is flawed. And that's because the Earlys may have put their eggs in the no inter vivos gift basket, and that may prevail or that may not prevail. But at least there might be evidence of all these admissions that they say Helen made through the years that the judge didn't really consider because those weren't the strategy they went through.
Yeah.
So, I mean, yeah, I don't know if there's good
There-
evidence of that or
There
not.
wasn't admissible evidence of admissions
Okay,
through the
well,
years.
I got you. You're arguing that it would be a bad argument. My only point is, it's kind of, it's an odd thing for us if we were to hypothetically say summary judgment should have not been granted,
Right.
to say we know what a fact finder would do below. Seems to me your argument needs to be no genuine dispute of material fact.
That
and-
is my argument. And the wrinkle is, to the extent that you have to draw inferences from documents that are just cold on the record, the district court can do that on summary judgment just as well as he can do that on a trial. So no, there is.
Right, but the inferences have to be drawn in favor of the non-moving party at summary judgment, right?
Right, right.
So he can do so, but what he can't do is do what he did here and draw them in your favor.
Well, I don't think he drew them in our favor. I think he drew them the only way he can. He read them and read what they said. That's all.
Thank you very much.
Thank you.
And,
I have a lot to
Yes.
address here, if I
well,
could. I say I have a lot to address here.
okay,
The,
7 minutes.
Mr. Elam's affidavit that counsel's talked about, that his mom had no room to put this, he wasn't born then in 1949. So how's he know why she had it or didn't have it? And when the father died, he was 10 days old. So that affidavit is meaningless and was just provided at the time of the summary judgment motion. The 1969 conversation by my client, Michael Early, says that he saw up until 1969 the illustrations in grandmom's home. So there is counter evidence. That's not 1960. The four-panel discussion, they are four separate panels. Is it smart to divide them? No. We offered to get together and see if we could auction them all together to maximize the benefits. But can they be divided if everybody's obstinate? Yes, they can be. Middle Eastern, I think they're called something or other, forgot right now, ultra panels have been divided over the centuries and go to different, it's not wise to take something apart, but it can be divided, so it can be divisible, so it's available for court action. If we were to win a trial or win here, and the clients cannot resolve this, then it goes to petition and things are divided, unless there's an agreement, even if it's not a good thing to do. Judge Harris, when you asked me about where was the discussions, between, which go to rebutting the presumption, yes, if we go, and I'll just cite these paragraphs rather than read them. In our initial brief at page 17, paragraphs 36 to 41. In our reply brief, and that includes the discussions of Michael Early and also Stephen Early.
So let me jump in, because I think it might have been me who asked that, for you to give it to us on reply. And I
I'm
think
sorry.
you're right, no worries.
It was you, I'm sorry.
Completely fine. I'll take that as a compliment.
I confuse them all the time.
I think it's fair to say you had numbered paragraphs in that factual section that you referenced some of that. I guess but in the arguments that you made, are you going to refer to me in pages in your argument where you argued those facts in the argument part of your brief?
No, but I'll do that if the court wants that. These are
But-
facts of record, I don't.
I'm trying to figure out if you made an argument to us or the district court that those facts rebutted the presumption. And listing them as facts may be a start, but usually if you're going, that's part of an argument that you rebutted presumption, I would look in your argument and see, okay, here's where I incorporated those facts into my argument that I rebutted the presumption.
Yeah, and also the briefing in that case also. Judge,
Yeah.
I'd be glad if you gave me a couple weeks to give you a letter of citations.
I don't want to, we got the briefs.
I
We got
I don't believe that I, for the first time, raised anything.
Okay, all right. We have your briefs, and I appreciate that. I think I know what's in there, but I'll double check.
In this. And also, one last thing, because I still have a little time. I still go back that inter vivos gift, and we have established it. Page 11, paragraph 6. The defendant admitted that the illustrations were at grandfather's early residence between his receipt in 1943 until he died. Paragraph 8, the appellee admits he has nothing in writing to show that there was any gift to the mother. Paragraph 9, the appellee admits that his mother married in 1949, moved to St. Louis without the illustrations. Paragraph 10, admitted by appellee's mother did not take actual possession of the
Can I
illustrations.
just ask you, I know the admitted facts, can you, just as long as we're talking about the inter vivos gift and whether there was one, so your colleague cited a bunch of DC cases saying, well, you don't always have to take actual delivery. Sometimes there's constructive delivery and that'll work. And I didn't understand you to be disagreeing with that in your reply brief as a matter of law. Just let me finish and you can tell me if I read it right. But more to be saying, well, there are no facts here showing constructive delivery either.
Yes, Your Honor, but even more specific than that, those are very narrow cases. And when they're talking about constructive possession, it's, hey, Johnny, I have a safety deposit box. I'm putting bonds in it, and here's a key to it, constructive possession. There's a case that talks about putting something in a trunk of a car and giving access to the person.
Right, I
It's not
looked at the cases. The cases say, like, right, you have to, like, done whatever is sort of practically reasonable.
Exactly.
Right, but I guess the argument
So-
here would be she's got nowhere to put the stuff, right? And so this might work as constructive delivery.
I would say it doesn't. I think that, and it was.
Well, I totally get that you would say that
I'm gonna give you-
it
I'm gonna give
doesn't.
you-
I'm just trying to figure out, I did not read your brief to be arguing with the statement of law in your colleague's brief about these DC cases, but rather to be saying on these facts, as we know them, there was also no constructive delivery.
That's correct.
Okay, thank you.
That's correct. I had something else to say, but you probably.
I'm sorry
glad
I cut you off, but I
forgot.
did want to just clarify that, take a minute and.
I think I
about it.
might have covered. Thank you very much.
Thank
I
you.
appreciate your time.
We will come down and greet counsel, and then we can adjourn court for the day.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.